There are moments when you realize someone has been lying to you, not with words, but with wood and wire and silence. My neighbor drove fence posts 47 feet onto my mountain property. He knew exactly what he was doing. He just never expected me to hire a surveyor. I did not yell. I did not confront him in his driveway. I made a phone call, ordered a survey, and started keeping records. What followed took 14 months. At the end of it, he lost the fence, lost the trail, and lost something he could never recover, not even in a courtroom. My name is Cole Merritt. I bought 43 acres in the mountains of western North Carolina in the spring of 2019. The property had been listed for nearly 2 years before I found it. The previous owner, an older man named Earl Bandy, had used the land for timber harvesting and deer hunting. When his health declined and he had no family nearby to take it over, he sold. The price was fair. The land was not glamorous. No postcard views, no creek, no old cabin waiting to be fixed up. What it had was acreage, elevation, and silence. That was enough. I had spent 22 years working in freight logistics. I was tired of movement, tired of noise, tired of managing things that belonged to other people. I wanted land I could walk, timber I could manage slowly, and a place where decisions felt permanent and mine. The property came with one feature I valued immediately: a logging trail. It ran along the eastern ridge, descending roughly 600 feet from the upper meadow down to the county road below. Earl had cut it years before for timber access, wide enough for an ATV, graded reasonably, shaded almost entirely by old hardwoods. I used that trail every single visit. My neighbor to the east was a man named Dennis Colton. He had owned his 31 acres for about 9 years before I arrived. His land sat lower on the slope. The ridgeline served as the rough visual boundary between our properties. He ran a small cattle operation, 6 or 8 head, and kept 2 horses in a lower pasture. We met the week I closed on the property. He walked up to the fence line near the county road and introduced himself. He seemed steady enough. We talked maybe 20 minutes. He mentioned that Earl had always allowed him informal access through the eastern side of the trail to service a spring box he maintained just below the ridge. I told him that was fine for the time being. We would work something out formally later. I did not think much of it at the time. I had no reason to. The first full summer on that land was the quietest I had known in years. I was not trying to develop the property. I had no timeline, no grand plan. I came up on weekends, sometimes midweek if work allowed. I walked the perimeter. I learned where the soil changed, where the hardwoods thinned, where the deer moved in the early morning. I marked a few dead ash trees for eventual removal. I noted where the drainage ran after heavy rain. The logging trail became my routine. Every visit started the same way. Park at the bottom near the county road gate, unlock the chain, drive the ATV up the eastern ridge, and spend the first hour just moving through the upper section of the property. It was not exercise. It was inventory. I was learning what I owned. Dennis Colton and I crossed paths occasionally. He would wave from his lower pasture. Sometimes he would stop his truck at the shared fence line and we would talk briefly. Weather, cattle prices, road conditions after storms, nothing significant. He never asked for anything formally. He occasionally used the lower end of the trail to access his spring box, just as Earl had allowed. I watched him do it twice that first summer and said nothing. I was not suspicious of him. There was no reason to be. The boundary between our properties was a legal line on a deed, and I assumed we both understood where it sat. That assumption would cost me months of documentation later. By the second summer, I had cleared 2 sections of deadfall along the upper meadow, had the trail graded once by a local operator with a small dozer, and had installed a better gate at the county road entrance. I put in a trail camera near the upper meadow, not pointed at Dennis's land, but facing the deer corridor that ran along the ridge. I was thinking about timber management, not disputes. The land felt settled. My relationship with it felt settled. That changed in late October of 2020. I drove up on a Saturday morning for what I expected to be a routine visit. The leaves were turning. The air was cold and dry. I unlocked the gate at the bottom, drove the ATV about 300 feet up the trail, and stopped. There was a fence. It crossed the trail completely. Metal T-posts, freshly driven. Barbed wire, 3 strands, tightly strung. The wire ran from a stand of white oaks on the left side of the trail into the brush on the right, disappearing into the tree line. It was not a temporary barrier. It was built to last. I sat on the ATV for a moment and looked at it. I did not touch it. I did not move it. I took out my phone and photographed it from 6 different angles before I did anything else. Then I turned around and drove back down to the gate. I sat in my truck at the bottom of the property for about 15 minutes before I did anything. I was not angry in the way most people expect. It was more like a cold clarity. Someone had built a structure on or near my property line without any conversation, without any notice, without any permission. That was either a mistake or a decision. Either way, it required a response, and that response needed to be measured. I drove home that afternoon without confronting Dennis. That was deliberate. I had photographs, but no measurements. I had a visual, but no legal reference. Walking up to a neighbor's door with photographs and no facts is not a confrontation. It is a complaint. Complaints without documentation go nowhere. The first thing I did Monday morning was pull out my deed. The property description was detailed, but written in the way older rural deeds often are. Meets and bounds, language referencing iron pins, bearing trees, and distances measured in chains. It was legally valid, but not easy to read without training. I understood the general shape of the parcel from the plat map attached to the deed. What I could not determine from the documents alone was the precise location of the eastern boundary relative to where that fence now stood. I called 3 survey companies that week. 2 were booked out past 90 days. The third, a firm out of Asheville, had a cancellation and could schedule a boundary survey within 3 weeks. I booked it immediately and paid the deposit. While I waited, I went back to the property twice. Both times I photographed the fence again. On the second visit, I brought a measuring tape and measured the fence line's position relative to the trail itself, not to determine the legal boundary, but to document the physical structure in detail. The fence crossed the trail at a point roughly 310 feet from the county road gate. The T-posts were spaced approximately 8 feet apart. The barbed wire was tight and showed no rust, meaning it had been installed recently. I also walked the fence line as far as I could follow it through the brush. It ran northeast from the trail, parallel to what I believed was the ridge, for at least 200 feet before the terrain made further tracking difficult without cutting through heavy undergrowth. There was no gate in the fence, no passage point, no provision for my access whatsoever. On my second visit, I also noticed something I had missed the first time. On the far side of the fence, in the direction of Dennis's property, the ground had been disturbed. Fresh tire tracks, wide spacing, likely a tractor or utility vehicle. And along the tree line, a section of brush had been cleared, maybe 30 feet wide, running parallel to the fence. Someone had been working on that side recently. I photographed everything. I dated every image in a written log I started keeping on paper that same week. Every entry included the date, time, weather conditions, and a precise description of what I observed. I did not write opinions. I wrote only facts. I also sent Dennis a short, factual text message that second week. I kept it brief. I told him I had noticed a new fence crossing the trail on the eastern side of my property and asked if he had any information about it. I did not accuse him of anything in that message. I asked a question. He replied the following morning. He said the fence was his. He said it had always been his understanding that the boundary ran along the trail itself, not east of it. He said Earl had told him years ago that the trail was the dividing line. He said he had simply formalized what had always been the arrangement. I read that message 3 times. Then I saved it, screenshotted it, and emailed it to myself with the date in the subject line. He had just put his position in writing. Dennis's text message told me several things at once. First, he was not going to admit wrongdoing. He had framed the fence as a clarification of an existing arrangement, not an encroachment. That framing was deliberate. It shifted the story from trespass to interpretation, a much harder thing to fight emotionally, though no harder legally. Second, he had referenced Earl Bandy as his source. Earl was elderly, in declining health, and had sold the property over a year ago. Whatever Earl had said to Dennis in passing conversation, if he had said anything at all, was not recorded, not notarized, and carried no legal weight against a recorded deed. But it gave Dennis a human story to tell if this ever reached a public forum. Third, and most importantly, he had committed to a position. He believed, or was claiming to believe, that the trail itself was the legal boundary. That claim was either genuine ignorance or calculated misdirection. Either way, the survey would settle it. I did not reply to his text that day. I waited 4 days before responding. When I did, I kept it to 2 sentences. I told him the property boundary was established by recorded deed and plat, not by informal conversation, and that I had engaged a licensed surveyor to locate the boundary markers. I sent that message at 9 in the morning on a Tuesday and went back to work. He did not reply for 6 days. When he did respond, the tone had shifted. He said he had spoken to someone, he did not say who, and that he was confident the boundary had been informally adjusted years before my purchase. He used the phrase long-standing use. He said he hoped we could work this out neighbor to neighbor without involving outside parties. I noted the phrase outside parties. Surveyors are not outside parties in a property dispute. They are licensed professionals whose job is to locate what already legally exists. His discomfort with that process told me something. I did not respond to that second message at all. There was nothing productive to say before the survey results were in hand. The surveyor arrived on a Thursday morning in mid-November. His name was Gary Phelps. He was thorough and unhurried. He had pulled the deed, the original plat, and the recorded subdivision documents for the area before he arrived. He brought 2 assistants. They worked the property for most of the day, locating iron pins along multiple boundary lines, cross-referencing distances, and running their equipment across the eastern ridge. I walked with Gary for part of the morning but stayed out of his way. I answered his questions about access points and gave him copies of my deed and the original plat I had on file. I did not tell him about Dennis or the fence. I simply asked for a full boundary survey with all corners located and documented. By mid-afternoon, they had found all 4 corner pins on the eastern boundary. Gary called me over to the ridge. He showed me the pin locations on his field notes. He pointed to where the legal eastern boundary ran. Then he turned and pointed to where Dennis's fence stood. The fence was 47 feet inside my property line, not a few inches, not an ambiguous overlap at a corner. 47 feet, measured cleanly, documented precisely, entered into the official survey record. I stood there and looked at the fence for a long moment. Then I thanked Gary, confirmed the timeline for the final survey document, and drove back down the trail. I had what I needed. The certified survey report arrived by email 12 days later. It was a formal document, stamped, signed, and sealed by Gary Phelps, licensed land surveyor, license number recorded on every page. It included a scaled drawing of my entire parcel with all 4 boundary lines plotted, all corner pins located and described, and a clear notation of the encroaching fence line with a measured distance of 47 feet from the legal eastern boundary. That document was now a matter of professional record. I printed 3 copies. One went into a manila folder in my filing cabinet. One went into a waterproof document sleeve I kept in my truck. The third I scanned and saved in 2 separate cloud locations with the date and the file name. I also ordered a certified copy of my original deed from the County Register of Deeds office. I wanted a clean chain of title in hand before anything escalated further. It arrived within a week. At this point, I had a recorded deed, an original plat, a certified boundary survey, time-stamped photographs of the fence taken on 4 separate dates, a written log of every site visit, and 2 text messages from Dennis, one admitting the fence was his, one referencing long-standing use, both saved and backed up. I was not ready to go to court, but I was ready to send a letter. I contacted a real estate attorney in Asheville named Patricia Horn. I found her through the North Carolina State Bar's referral directory. I was not looking for someone aggressive. I was looking for someone precise. Her reviews mentioned thoroughness and clear communication. That was enough. I sent her everything: the deed, the plat, the survey, the photographs, and printed copies of both text messages. I wrote a 1-page summary of the timeline in plain language and attached it to the front of the packet. She reviewed the materials and called me within 3 days. Her assessment was direct. The encroachment was clear, documented, and legally indefensible. Dennis had no easement on record, no adverse possession claim that could survive scrutiny given the timeline, and no legal basis for the fence's current position. She recommended a formal demand letter as the first step. Certified mail, return receipt, giving Dennis 30 days to remove the fence and restore the trail to its previous condition. I authorized the letter. It went out on a Monday morning in early December. Dennis signed for it 4 days later. I have the return receipt. He called me the same evening. I did not answer. He left a voicemail. His tone in that voicemail was not what I expected. He was not apologetic. He was not hostile either. He was measured in a way that felt rehearsed, as if someone had coached him before he called. He said he had received the letter, that he disagreed with its characterization of the situation, and that he intended to seek his own legal counsel. He said he hoped this could still be resolved without further escalation. I saved that voicemail immediately. I transcribed it word for word into my written log that same night, noting the time of the call and the exact duration. Then I waited. 30 days passed. The fence did not move. When the 30-day deadline passed without any action from Dennis, I called Patricia Horn the following morning. She was not surprised. She told me that in her experience, neighbors who retain counsel and then go quiet are usually being advised to wait, to see if the other party will lose patience, escalate emotionally, or make a procedural mistake. Patience itself was a legal strategy on his end. I told her I understood. I told her I had no intention of losing patience. She outlined the next steps. We could file a civil action in Superior Court for trespass, ejectment, and injunctive relief, essentially asking the court to order the fence removed and award damages for the period of unlawful obstruction. She estimated the filing process would take several weeks to prepare properly. She wanted to do one additional thing before filing: send a second letter, this time with the survey attached as a formal exhibit, giving Dennis a final 10-day window to act voluntarily. The reasoning was practical. A judge looks more favorably on a plaintiff who gave the opposing party every reasonable opportunity to resolve the matter without litigation. 2 documented demand letters, both ignored, built a stronger record of bad faith on Dennis's part. I agreed. The second letter went out in mid-January. Dennis's attorney responded this time, not Dennis directly. The response came on law firm letterhead from a solo practitioner in a town about 40 miles away. The letter was 2 pages. It argued that Dennis had maintained continuous, open, and notorious use of the area in question for a period exceeding the statutory requirement for adverse possession in North Carolina, which is 20 years. It claimed that Earl Bandy had verbally acknowledged the informal boundary adjustment. It requested that I cease and desist from harassment and threats of litigation. I read that letter twice at my kitchen table. Then I called Patricia. She was calm. She walked me through each claim methodically. On adverse possession, Dennis had owned his property for 9 years. The statutory period in North Carolina is 20 years. His own attorney's letter had just confirmed a timeline that disqualified the claim entirely. On Earl's alleged verbal acknowledgement, verbal statements by a prior owner carry no legal weight against a recorded instrument. They cannot modify a deed. They cannot create an easement. They are legally irrelevant. The cease and desist demand, she said, was noise. An attempt to reframe the situation as mutual aggression rather than unilateral encroachment. She recommended we file. I authorized the filing that same afternoon. The civil complaint was submitted to the Superior Court clerk in late January. It named Dennis Colton as defendant, cited trespass and ejectment, requested injunctive relief requiring immediate removal of the fence, and sought damages for loss of use of the trail from the date of construction through the date of resolution. Dennis was served 11 days later. I drove up to the property the weekend after the filing. The fence was still there. The trail was still blocked, but something had changed in how I saw it now. It was no longer an obstacle. It was evidence. Every day that fence remained standing after service of process was another day added to the damage calculation. I took photographs again, dated, logged, filed. After the complaint was filed, Patricia advised me to shift my focus entirely to evidence building. The legal process would move at its own pace. Court dates, discovery periods, motion filings. None of that was within my control. What was within my control was the quality and completeness of my documentation. She told me that property encroachment cases are won or lost on paper, not on courtroom speeches. The side with the cleaner record almost always prevails. I had already started strong, but I needed to go deeper. The first thing I did was commission a second visit from Gary Phelps. I asked him to return to the property and produce a supplemental report, specifically a detailed measurement of the fence line's full extent across my property. The original survey had established the 47-foot encroachment at the trail crossing point, but I needed the complete picture. How far did the fence run across my land in total? Where did it begin, and where did it end, relative to my legal boundary? Gary returned on a February morning. The ground was frozen and the brush was bare, which made visibility through the tree line much better than during the November survey. He walked the entire fence line within my property boundary and produced a supplemental measurement report. The results were more significant than I had anticipated. The fence did not simply cross the trail. It ran for 231 feet across my property, entering my boundary near a stand of white oaks on the southern end and terminating at a rock outcropping on the northern end. The entire 231-foot length sat inside my legal boundary, ranging from a minimum intrusion of 39 feet to a maximum of 52 feet at the widest point. This was not a fence built in confusion. A person does not accidentally construct 231 feet of barbed wire fencing in a straight, deliberate line while consistently remaining 40 to 50 feet inside someone else's property. The uniformity of the intrusion itself suggested intentional placement. Gary's supplemental report was stamped and sealed. I filed it immediately with Patricia as a second exhibit to the existing complaint. The next documentation layer was photographic continuity. I had photographs from 4 dates before the filing. I now needed a consistent visual record moving forward. Proof that the fence remained in place throughout the litigation period, that no modifications were made to it, and that my trail access remained completely blocked. I visited the property every 2 weeks from February through June. Each visit followed the same protocol. I photographed the fence from the same 3 positions each time, from the trail approach, from the northern end, and from the southern end near the white oaks. I photographed the blocked trail entrance. I noted the date, time, and weather conditions in my written log and attached the corresponding photo file numbers to each entry. By April, I had 14 separate dated site visit records, each with multiple photographs and written descriptions. I also went back to the county tax records and pulled Dennis's property documents. I wanted to understand exactly what he claimed to own, his deed description, his plat, his recorded acreage. I compared his legal boundary description against mine. His eastern boundary, as described in his own recorded deed, stopped well short of the trail. His deed did not reference the trail as a boundary marker in any form. It used iron pins and bearing trees, the same meets and bounds language as mine. and those references placed his legal boundary consistently to the east of where his fence now stood, not west of it. His own deed contradicted his position entirely. I had Gary review Dennis's deed description as part of a written professional opinion. Gary confirmed in a signed letter that Dennis's recorded boundary, plotted against the survey data, placed the fence entirely within my property under any reasonable interpretation of either deed. That letter became Exhibit 3. With the physical and survey documentation solid, I turned to the historical record. If Dennis intended to argue long-standing use or informal boundary adjustment, I needed to understand the actual history of that land. Not his version of it, but the documented version. That meant going back further than my own purchase. I started at the County Register of Deeds office. I spent a full afternoon there with a clerk who helped me pull the chain of title on my parcel going back 40 years. I was looking for any recorded easement, any boundary adjustment agreement, any document that might reference the trail or the eastern boundary in a way that could support Dennis's position. There was nothing. No recorded easement. No boundary line agreement. No survey amendment. No deed modification of any kind, referencing the eastern boundary or the logging trail. The boundary had been where the deed said it was, unchanged, for every transaction in the recorded history of that parcel. I requested certified copies of the 3 most recent deeds in the chain of title and added them to my evidence file. Next, I tracked down Earl Bandy. This required some effort. Earl had moved to an assisted living facility in Tennessee after the sale. I found the facility through a combination of public records and a conversation with a neighbor down the county road who had known Earl for years. I called the facility, explained that I was the purchaser of Earl's former property, and needed to speak with him briefly regarding a legal matter involving the land. Earl agreed to speak with me. We talked by phone for about 35 minutes. I was careful with my questions. I did not lead him. I did not suggest answers. I simply asked him what he remembered about the eastern boundary of the property, whether he had ever made any agreement with Dennis Colton regarding the trail or the boundary line, and whether he had ever verbally acknowledged any informal adjustment to the boundary. Earl's answers were clear. He said he had never agreed to any boundary adjustment with Dennis. He said he had allowed Dennis occasional access to the spring box as a neighborly courtesy, nothing more. He said the trail had always been entirely on his property, that he had cut it himself in the early 1990s, and that it had never served as a boundary marker of any kind. He said Dennis had asked him once, several years before the sale, whether he would consider selling the strip of land along the eastern ridge. Earl had declined. That last detail stopped me. Dennis had tried to buy that strip of land. Earl had refused, and now Dennis had simply built a fence across it and claimed it as his own. I asked Earl if he would be willing to put his recollections in writing. He was willing. I arranged for a simple written statement to be prepared, not a formal affidavit at that stage, but a signed, dated letter in his own words, describing what he had told me on the phone. A notary at the assisted living facility witnessed his signature. That signed statement became Exhibit 4. I also pulled the aerial photography records for the property through the county GIS system. The county maintained historical aerial images going back to 2005. I reviewed every available image for the eastern boundary area. In every aerial image from 2005 through 2019, 14 years of photographic record, there was no fence visible along the eastern ridge within my property boundary. The first image showing any fence structure in that location was from a 2021 update, taken after Dennis had built it. The aerial record confirmed the fence was new. It had not existed during any period that could support an adverse possession argument, even if the statutory timeline had been met, which it had not. I compiled a written summary of the aerial findings, attached printed screenshots from the GIS system with dates and coordinates labeled, and added it to the file as Exhibit 5. Discovery began in late March. In civil litigation, discovery is the formal exchange of evidence between both parties before trial. Each side submits written questions called interrogatories, requests for production of documents, and requests for admission. The opposing party must respond within a set time frame under oath. Patricia prepared our discovery requests carefully. We asked Dennis to identify every document, photograph, or record he possessed that supported his boundary claim. We asked him to identify every person with knowledge of the alleged informal boundary arrangement. He seemed steady enough. We talked maybe 20 minutes. He mentioned that Earl had always allowed him informal access through the eastern side of the trail to service a spring box he maintained just below the ridge. I told him that was fine for the time being. We would work something out formally later. I did not think much of it at the time. I had no reason to. The first full summer on that land was the quietest I had known in years. I was not trying to develop the property. I had no timeline, no grand plan. Patricia examined the handwritten note carefully. There was no date on it, no witness signature. No reference to the trail as a boundary. It simply said, in Earl's alleged handwriting, that Dennis could use the Eastern Trail for access to his spring. Even if genuine, it described a permissive license, a courtesy, not a property right. A license does not survive the sale of the property that granted it. It does not transfer with the deed. It does not create an easement. More importantly, Earl had already told me in his signed statement that he had never made any written agreement with Dennis. Either the note was fabricated, or Earl had forgotten writing a casual, informal note that he did not consider significant. Either way, it carried no legal weight as a property claim. Patricia submitted Earl's signed statement to Dennis's attorney, along with a formal challenge to the note's authenticity and legal relevance. Dennis's attorney filed a motion to exclude Earl's statement on the grounds that Earl had not been formally designated as a witness within the discovery period. It was a procedural challenge, not a challenge to the substance of what Earl had said. Patricia responded swiftly. She filed a motion to supplement the witness list with proper notice and submitted Earl's statement as a sworn affidavit arranged remotely with a notary at the Tennessee facility. Earl signed it without hesitation. The court granted the supplement. The exclusion attempt had failed, but Dennis's attorney was not finished with procedural maneuvering. He filed a motion for summary judgment in April, arguing that even accepting all of my evidence as true, the court should rule in Dennis's favor as a matter of law, because the alleged informal arrangement with Earl constituted a license that I had continued by allowing Dennis to use the trail after my purchase. That motion rested entirely on my first conversation with Dennis, when I had told him the Springboks access was fine for the time being. I had said those words. I remembered saying them. And now they were being used to argue that I had ratified an informal arrangement that somehow justified a permanent fence 47 feet inside my property. I sat with Patricia in her office on a Wednesday afternoon and went through the motion line by line. She was not concerned. A permissive license, she explained, does not authorize the construction of permanent structures on the licensor's property. Allowing someone to walk across your land does not give them the right to fence it. The two things are legally distinct. His motion conflated access permission with ownership rights, a significant overreach that she was confident the court would reject. She filed the response brief 2 weeks later. It was precise and thorough. It cited controlling North Carolina case law on the distinction between licenses and property rights, attached the full survey record, and included a direct quote from Dennis's own interrogatory response admitting he had no recorded easement. The court denied the summary judgment motion in early May. The denial of the summary judgment motion changed the dynamic. Up until that point, Dennis's attorney had been controlling the pace through procedural filings. Each motion had forced Patricia to respond, consuming time and resources. It was a delay strategy, not unusual in property disputes where one side hopes the other will settle out of financial exhaustion rather than principle. But when the summary judgment failed, the delay strategy lost its primary tool. The case was now moving toward trial on a fixed schedule. A pre-trial conference was set for late June. The trial itself was calendared for September. Dennis had 4 months to either settle or go to court with what he had. What he had was thin. A single undated handwritten note of questionable origin. A photograph with no identifying context. A contractor receipt that confirmed the fence was built after my purchase. An adverse possession argument that his own attorney's letter had disqualified by stating a 9-year ownership period. And a verbal account of what Earl had allegedly said, now directly contradicted by Earl's sworn affidavit. Against that, I had a certified boundary survey with a supplemental report, a complete chain of title showing no recorded easement, 14 years of aerial photography showing no prior fence, Earl's sworn statement, Dennis's own text messages, a professional opinion letter from the surveyor, and a documentation log spanning 8 months of consistent site visits. The evidentiary gap between our two positions was not close. Patricia arranged a settlement conference for late May at her office. Dennis attended with his attorney. I attended with Patricia. The meeting lasted about 2 hours. Dennis's attorney opened by proposing that Dennis be granted a formal easement across the Eastern Trail in exchange for relocating the fence to the legal boundary. He framed it as a practical compromise. Dennis would give up the land claim, I would give up the damages claim, and both parties would walk away with something. I listened to the full proposal before responding. Then I told Patricia, clearly and without hesitation, that I was not interested in granting any easement. Dennis had no legal right to an easement. He had not asked for one through proper channels. He had instead built an unauthorized fence across my property, blocked my trail access for months, and spent the better part of 5 months filing procedural motions to delay accountability. Rewarding that conduct with a formal easement was not a resolution. It was a concession to bad behavior. Patricia communicated my position to his attorney without embellishment. Dennis's attorney asked for a recess. They stepped out for about 15 minutes. When they returned, The proposal had changed. Dennis would remove the fence entirely and pay a reduced damages figure, half of what our complaint had sought. In exchange, I would agree not to pursue any further legal action related to the fence or the trail. I asked Patricia what she thought of the number. She told me the full damages figure was supportable at trial, but that collection after judgment could take time. The reduced offer was immediate and certain. She laid out both paths clearly and told me the decision was mine. I thought about it for a moment. Then I declined the reduced offer as well. My reasoning was straightforward. The full damages figure represented real loss, months of obstructed access to land I owned and paid for. Accepting half of it without a clear explanation of why the other half was being forgiven sent the wrong signal. More importantly, I wanted the fence removal documented as a court order, not a private agreement. A private settlement could be renegotiated, disputed, or ignored. A court order carried enforcement mechanisms that a handshake arrangement did not. The settlement conference ended without resolution. We were going to trial. The pre-trial conference took place on a Thursday morning in late June. Both attorneys presented their witness lists, exhibit lists, and proposed jury instructions to the judge. The case was assigned to a Superior Court judge named Honorable Raymond Stafford. He reviewed the materials briefly, asked several pointed questions about the adverse possession timeline, and noted on the record that the statutory period issue appeared to present a significant obstacle for the defense. Dennis's attorney did not respond to that observation directly. He simply said the defense intended to present testimony regarding the historical use of the property. Judge Stafford set the trial for the second week of September and adjourned. Walking out of that courthouse, Patricia told me something I found useful. She said judges who ask pointed questions during pretrial conferences are usually signaling what they have already noticed in the paperwork. Judge Stafford had gone directly to the adverse possession timeline. That was not accidental. I filed that observation away and focused on the remaining preparation. Patricia and I spent July and August building the trial presentation methodically. Every exhibit was labeled, organized, and cross-referenced. Gary Phelps was confirmed as an expert witness. He would present both survey reports and the professional opinion letter, and he would walk the court through the boundary line on a scaled exhibit map. Earl Bandy would testify remotely by video deposition from Tennessee. Patricia had arranged the technical setup with the court clerk's office. I would testify as the primary fact witness. We prepared my testimony carefully. Patricia walked me through every question she intended to ask, and every question she anticipated from Dennis's attorney. She told me the same thing before every session. Answer what is asked. Nothing more, nothing less. Do not explain. Do not justify. Do not volunteer. I practiced that discipline until it felt natural. In late July, something happened that I had not anticipated. A man named Robert Tillis contacted me by email. He introduced himself as a property owner 2 parcels north of mine along the same ridge. He said he had heard through a neighbor that I was in a legal dispute with Dennis Colton over the eastern boundary. He said he had relevant information and asked if I was willing to speak with him. I forwarded the email to Patricia before responding. She told me to arrange a call with her present. We spoke with Robert Tillis on a Tuesday afternoon in early August. What he told us was significant. Robert said that approximately 3 years before my purchase, so around 2016, Dennis had approached him about a similar boundary matter on the northern end of Dennis's property. Dennis had claimed that a section of Robert's fence line was encroaching on his land. Robert had hired a surveyor. The survey had shown that Robert's fence was correctly placed and that Dennis's claim had no merit. Dennis had dropped the matter after receiving the survey results. Robert still had his survey report and the written correspondence from that dispute. He had kept everything in a file. Patricia asked him directly whether he would be willing to testify or provide a sworn statement. He said yes without hesitation. His willingness to testify was valuable not because his dispute was legally identical to mine. It was not. It was valuable because it established a pattern. Dennis had made a boundary claim against a northern neighbor using the same approach. Verbal assertion, informal history, pressure without documentation. When confronted with a professional survey, he had retreated. He had used the same playbook twice. The difference this time was that he had gone further. He had actually built the fence before being challenged. Patricia prepared Robert Tillis as a supplemental witness. His survey report from 2016 and his written correspondence with Dennis were added to our exhibit list as pattern evidence. Dennis's attorney filed an objection to the admission of the Tillis evidence on relevance grounds. Patricia responded with a brief arguing that the evidence was admissible to demonstrate a consistent course of conduct, that Dennis had a documented history of making unsupported boundary claims against adjacent landowners. The court ruled on the objection in late August. The Tillis evidence was admitted. The week before trial, Dennis's attorney made one final attempt to reframe the case. He filed a motion in limine, a pre-trial motion asking the court to exclude specific evidence before trial begins. He targeted 3 items. First, the aerial photography from the county GIS system, arguing it had not been properly authenticated as an official public record. Second, Robert Tillis's testimony, revisiting the relevance objection the court had already ruled on. Third, Earl Bandy's video deposition, arguing that the remote testimony format did not meet the evidentiary requirements for sworn testimony in a North Carolina civil proceeding. Patricia responded to each challenge in a single consolidated brief filed 2 days later. On the aerial photography, she submitted a certification letter from the county GIS administrator confirming the images were official public records maintained in the ordinary course of government business. That met the authentication standard completely. On the Tillis testimony, she cited the court's own prior ruling admitting the evidence and noted that filing a second objection on identical grounds without new legal authority was procedurally improper. On Earl's deposition, she attached the remote deposition protocol documentation, the notary certification from Tennessee, and the signed consent form Earl had completed. Every procedural requirement had been met. Judge Stafford denied all 3 exclusion requests the following morning. The ruling was brief and direct. He noted in his order that the GIS certification resolved the authentication question, that the Tillis ruling stood, and that the deposition had been conducted in full compliance with applicable procedure. Dennis had exhausted every pretrial avenue available to him. Trial began on a Tuesday morning in the second week of September. The courtroom was not large. There was no jury. This was a bench trial, meaning Judge Stafford would decide both the facts and the law. That suited our case well. The evidence was documentary and technical. A judge with legal training was better positioned to evaluate a certified survey report than a jury hearing about metes and bounds language for the first time. Patricia opened with a clear, structured statement. She told the judge exactly what the case was about in 3 sentences. A neighbor built a fence. A licensed survey proved it sat 47 feet inside my property. Every document in the record confirmed it had no legal basis. She did not dramatize. She did not editorialize. She presented the framework and sat down. Dennis's attorney opened with a longer statement. He spoke about the history of the land, about Earl Bandy's neighborly relationship with Dennis, about the informal understandings that govern rural property in communities where people have lived side by side for decades. He asked the court to consider the human context behind the legal documents. Judge Stafford listened without expression. Gary Phelps testified first. He was methodical and precise. He explained the survey process, identified each boundary pin location, walked the court through the scaled exhibit map, and stated clearly that the fence line, as built, encroached 47 feet into my property at the trail crossing point and ran 231 feet across my legal boundary in total. He presented the supplemental report. He presented his professional opinion letter regarding Dennis's deed boundary. Dennis's attorney cross-examined Gary for about 40 minutes. He focused on whether natural features like the ridgeline could serve as boundary indicators, whether the original iron pins might have shifted over time, and whether informal use patterns had any surveying significance. Gary answered each question without irritation. Natural features are not legal boundaries unless specifically referenced in a recorded deed. Iron pins are set in bedrock or buried below frost line. They do not shift. Informal use patterns have no relevance to a licensed boundary survey conducted from recorded instruments. Every challenge dissolved under direct technical response. Earl Bandy's video deposition played on the second morning of trial. The setup was straightforward. A large monitor had been positioned facing the judge's bench. Earl appeared on screen from a small conference room at the assisted living facility in Tennessee. He was seated at a table, visibly older than I had imagined from our phone conversation, but composed and clear. Patricia conducted the direct examination remotely. She walked Earl through his history with the property, how long he had owned it, how he had used the logging trail, what his understanding of the eastern boundary had always been. Earl answered in short, direct sentences. He said the trail had been entirely on his land since he cut it. He said the eastern boundary had never been a point of confusion or dispute during his ownership. He said he had never made any agreement with Dennis Colton to adjust, share, or informally transfer any portion of the eastern boundary area. Patricia then asked him about the handwritten note Dennis had produced in discovery. Earl looked at the copy shown to him on screen. He studied it for a long moment. He said he did not recognize the handwriting as his own. He said the phrasing did not sound like something he would have written. He said he had never given Dennis any written permission of any kind, only a verbal understanding that Dennis could access the spring box as a neighborly courtesy, which he had also extended to another neighbor on the western side for a different matter. He was clear that courtesy access and property rights were 2 entirely different things in his understanding. Dennis's attorney cross-examined Earl for about 25 minutes. He pressed him on his age, his memory, and the possibility that he might have written a casual note and forgotten it. Earl acknowledged that his memory was not what it once was, but he was firm on the core points. He had never agreed to any boundary adjustment. He had never treated the trail as anything other than his own property. He had declined Dennis's offer to purchase the eastern strip years before the sale. That last point landed visibly in the courtroom. Dennis's attorney did not follow up on it. I testified after Earl's deposition concluded. Patricia took me through the full timeline. My purchase, my discovery of the fence, the survey, the text messages, the demand letters, the documentation process. I answered every question in plain language. I did not editorialize. I presented facts and dates. When she introduced the text messages as exhibits, I confirmed they were accurate records of the exchange. Dennis's attorney cross-examined me for roughly 30 minutes. He focused primarily on my initial conversation with Dennis at the fence line, specifically my statement that spring box access was fine for the time being. He asked me several variations of the same question, attempting to establish that I had knowingly continued an existing arrangement. I answered each variation the same way. I had told Dennis the access was fine temporarily, pending a formal arrangement. I had never agreed to any boundary modification. I had never seen any fence on the property before October 2020. I had never given anyone permission to construct a permanent structure on my land. He moved to questions about the handwritten note, asking whether I could prove it was fabricated rather than simply misremembered by Earl. I told him I could not prove what was in Earl's mind. What I could confirm was that the note, even if genuine, described access permission, not a property right, and that access permission did not authorize fence construction under any legal framework I was aware of. He had no productive follow-up to that answer. Robert Tillis testified in the afternoon. He described his 2016 boundary dispute with Dennis in measured, factual terms. He presented his survey report. He presented the written correspondence. He described how Dennis had dropped the matter entirely once the survey results were delivered. The courtroom was quiet through most of his testimony. Dennis testified on the third morning. His attorney conducted the direct examination carefully, keeping the questions broad and the answers narrative. Dennis spoke about his years on the property, his relationship with Earl, the informal understandings he said had governed the eastern boundary since before my purchase. He described Earl as a man who valued neighborly arrangements over legal formalities. He said the trail had functioned as a practical dividing line between their two properties for as long as he could remember. He spoke calmly. He was not aggressive on the stand. He had clearly been prepared, but preparation only takes a witness as far as the facts allow. Patricia's cross-examination began with a single document, Dennis's own deed. She asked him to confirm that the deed described his eastern boundary using specific iron pins and bearing distances. He confirmed it. She asked him to confirm that his deed made no reference to the logging trail as a boundary marker of any kind. He confirmed that as well, after a pause. She then placed the scaled survey map on the exhibit easel, the same map Gary Phelps had walked the court through on the first day. She asked Dennis to identify where his legal eastern boundary ran on that map. He pointed to a line. She asked him to identify where his fence stood on the same map. He pointed to a second line, visibly further west. She asked him to describe, in his own words, what the space between those two lines represented. He said it represented the disputed area. She corrected him gently, but directly. She told him that the space between those two lines was not disputed. It had been measured by a licensed surveyor from Recorded Instruments. It was my property, and his fence sat inside it. His attorney objected that Patricia was testifying rather than questioning. Judge Stafford overruled the objection. Patricia moved to the handwritten note. She asked Dennis when Earl had given it to him. He said he could not recall the exact year. She asked him why the note had no date on it. He said Earl had never been formal about such things. She asked him whether anyone else had been present when Earl gave him the note. He said no. She asked him whether he had mentioned the note's existence at any point during the 2 text message exchanges with me before litigation began. He said no. She asked him why. He said it had not occurred to him. She let that answer sit for a moment before moving on. She asked him about the 2016 boundary dispute with Robert Tillis. His attorney objected immediately on relevance grounds. Judge Stafford overruled, citing his prior ruling admitting the Tillis evidence. Dennis confirmed the 2016 dispute had occurred. He said it was a different situation. Patricia asked him how it was different. He said the Tillis boundary had been clearly documented. She asked him whether my boundary was not also clearly documented. He did not answer directly. She asked him one final question. She asked him whether, at the time he drove the first fence post into the ground in September 2020, he had obtained a survey confirming the fence's placement was within his own legal boundary. He said no. She sat down. Dennis's attorney conducted a brief redirect, attempting to rehabilitate the narrative around Earl's note and the informal arrangement. But the damage from cross-examination was visible. The core of Dennis's position had always depended on the court accepting his version of an unrecorded, unwitnessed, undated arrangement over a certified survey, a sworn affidavit, 14 years of aerial photography, and 2 corroborating deed descriptions. Closing arguments were brief. Patricia summarized the evidence in under 15 minutes, methodically connecting each exhibit to the legal elements of trespass and ejectment. Dennis's attorney argued that the human context of rural property relationships deserved weight alongside technical documentation. Judge Stafford thanked both attorneys and said he would issue a written ruling within 30 days. The trial ended on a Wednesday afternoon. I drove back to the mountains that evening. I parked at the bottom gate and walked up the trail on foot in the fading light. I stopped at the fence. I looked at it one last time in the way you look at something you know is already finished, even before the paperwork confirms it. Judge Stafford's written ruling arrived 23 days after the trial concluded. Patricia called me before she emailed it. She told me the ruling had come in and that I should read it carefully from the beginning rather than skipping to the conclusion. She said it was thorough. She was right. The ruling was 19 pages. Judge Stafford had written it with the same precision a good surveyor brings to fieldwork, methodical, referenced, and without unnecessary language. He opened by summarizing the central legal question: whether Dennis Colton had any cognizable legal right to maintain a fence structure on Cole Merritt's recorded property, and if not, what remedy was appropriate. He addressed the adverse possession claim first. He noted that North Carolina General Statute 1-40 requires a claimant to demonstrate 20 years of open, notorious, continuous, and hostile possession. Dennis had owned his adjacent property for 9 years at the time of the fence construction. He had presented no evidence of any prior possessory claim by any predecessor in title. The adverse possession argument failed on its face. The court did not need to reach the other elements of the claim because the statutory period was plainly unmet. He addressed the license argument next. He acknowledged that Earl Bandy had extended a permissive license to Dennis for spring box access. He noted that a permissive license is, by legal definition, a personal privilege that does not run with the land and does not survive a change in ownership of the servient property. My purchase of the property in 2019 had extinguished whatever informal license Earl had extended. Even if I had verbally continued that courtesy in my initial conversation with Dennis, a verbal continuance of an expired personal license does not authorize the construction of permanent structures on the licensor's property. The license argument failed entirely. He addressed the handwritten note with particular directness. He found the note to be of uncertain authenticity, given Earl Bandy's sworn testimony that he did not recognize it as his own writing. He further found that even accepting the note as genuine, its content described access permission only, not any property right, boundary adjustment, or easement. I was not suspicious of him. There was no reason to be. The boundary between our properties was a legal line on a deed, and I assumed we both understood where it sat. That assumption would cost me months of documentation later. By the second summer, I had cleared 2 sections of deadfall along the upper meadow, had the trail graded once by a local operator with a small dozer, and had installed a better gate at the county road entrance. I put in a trail camera near the upper meadow, not pointed at Dennis's land, but facing the deer corridor that ran along the ridge. I was thinking about timber management, not disputes. The land felt settled. My relationship with it felt settled. That changed in late October of 2020. I drove up on a Saturday morning for what I expected to be a routine visit. Dennis Colton owed me $17,600 and had 45 days to tear down every post and strand of wire he had driven into my mountain. I read the ruling twice at my kitchen table. Then I put it in the manila folder with everything else: the deed, the surveys, the photographs, the text messages, Earl's affidavit, the aerial records, the Tillis documents, and every written log entry from 22 months of careful, patient documentation. The folder was thick. It had earned its thickness. Dennis removed the fence on a Saturday morning, 38 days after the judgment. I was not there when it happened. I had no interest in watching. A neighbor down the county road texted me a photograph that afternoon. Dennis and another man pulling T-posts with a tractor, coiling barbed wire onto a wooden spool. The trail was visible in the background, open and unobstructed for the first time in nearly 2 years. I drove up the following morning alone. I parked at the bottom gate, unlocked the chain, and drove the ATV up the eastern ridge the same way I had done hundreds of times before the fence appeared. The trail was intact. The post holes had been filled, not perfectly but adequately. The wire was gone. The white oaks on the southern end stood undisturbed. The rock outcropping on the northern end looked exactly as it always had. 231 feet of unauthorized fencing, gone. I drove the full length of the trail up to the upper meadow and sat there for a while in the quiet. The hardwoods were turning again. It was mid-October, almost exactly 2 years from the morning I had first found the fence blocking my path. The light through the canopy was the same pale gold it had been that first morning. The air carried the same cold dryness. Nothing about the land had changed. It had simply been returned to what it had always legally been. Patricia's office handled the judgment collection through the court's enforcement process. Dennis paid in 2 installments. The first within 30 days of the judgment, the second 6 weeks later. The full $17,600 was received and disbursed. Patricia's fees were covered entirely by the court-ordered award. My out-of-pocket costs for the surveys, the deed research, the document filing, and the travel across 22 months of litigation came to just under $4,000. The financial accounting was not the point. It never had been. Dennis Colton had calculated that I would not fight. That calculation was wrong from the first morning I sat on that ATV and took photographs instead of pulling the wire down with my hands. I never saw Dennis after the trial. He did not attempt any further contact. His property sat quiet through that fall and winter. His cattle grazed in the lower pasture the same as always. Whatever he told himself about what had happened, he kept it to himself. That suited me fine. The trail camera I had installed near the upper meadow had captured 47 months of movement along the eastern ridge by the time the case concluded: deer, turkey, 1 black bear in the spring of 2021, and on 2 occasions, Dennis's truck moving along the lower fence line near his spring box. I reviewed the full archive that November evening, sitting at my kitchen table with a cup of coffee, going through each month in sequence. There was something quietly satisfying about that archive. It had recorded everything the land had witnessed, including the period when someone had tried to take a piece of it. The land had not changed. The record had not changed. Only the fence was gone. I have thought about this situation many times since the fence came down. Not with anger. Not with satisfaction either. At least, not the kind that fades quickly and leaves nothing behind. Something more durable than that. A settled understanding of what the experience actually demonstrated. Property rights are not abstract concepts. They are recorded instruments, measured distances, and documented facts. They exist on paper, in deed books, in survey files, and in county records that predate every person currently living on any given piece of land. They do not bend to verbal claims, informal arrangements, or the passage of time alone. They bend only to the legal processes designed to modify them. And those processes require documentation, proper notice, and recorded evidence. Dennis Colton did not lose because I was clever. He did not lose because I was aggressive or well-connected or lucky. He lost because he built a fence without a survey, claimed a boundary without a deed, and assumed that a neighbor's patience was the same thing as a neighbor's ignorance. Those are 3 different mistakes. Each one was recoverable on its own. Together, they were not. The lesson I carry from those 22 months is simple. When something is wrong on your land, do not react, document. Do not confront, record. Do not assume the problem will resolve itself. Measure it, photograph it, date it, and file it. The legal system moves slowly, but it moves toward evidence. Give it enough evidence, and it will carry the weight for you. I also think about Earl Bandy occasionally, an elderly man who built a trail through his own timber, lived quietly on his mountain for decades, and extended a simple neighborly courtesy to the man next door. That courtesy was later used, or attempted to be used, as the foundation for a permanent property claim. Earl had no way of knowing that would happen. Most people who extend kindness to neighbors do not draw up legal frameworks around it. They simply trust. That trust was abused. The court recognized it. Earl's own sworn words corrected the record. There is something important in that. A man in his 80s, living in a care facility in Tennessee, took the time to sign an affidavit and testify by video because the truth of what had happened on his land mattered to him. He did not have to do that. He chose to. I am still on that mountain. The logging trail runs the same path it always has, from the upper meadow down the eastern ridge to the county road gate below. The hardwoods close over it in summer and bare themselves in winter. The deer still move through the corridor along the ridge in the early morning. The trail camera still runs. I manage the property the same way I always intended to. Slowly, carefully, without urgency. The boundary is where it has always been. 43 acres, recorded, surveyed, and mine. No fence crosses it now.